reasons that can't be done this year. So we were certainly fortunate and privileged to have Diane be our guest speaker today to celebrate Juneteenth with us. And thanks, Reverend Grant, again for the excellent Juneteenth service today. And now, without further discussion, you all know what Juneteenth is all about. I don't really think I have to do that over again, but just briefly. Juneteenth is the oldest celebration commemorating slavery in the United States, dating back to 1865, June 19th, 1865. And when General Granger docked into Galveston and letting the slaves know that they've been freed. Now, if you know, this was 2 years after the Emancipation Proclamation. No one knows why it took 2 years, except there are many different theories, and I won't go into all of those, except it was June 19th, 1865, that slaves in Galveston were finally freed. This year, we have a lot to discuss and a lot to think about, and Diane will bring us up to date on all of it. And without further discussion, I'd like to present to you Diane Sammons again. Okay, thanks, Diane. It's on to you. Diane? Alita? Hello? I'm not.
Clarence, I am unmuting Diane. She's unmuted now.
Okay,
I'm unmuted.
Okay, it's on her now. Thanks, Diane. You may start.
Thank you. It's really my privilege to be here with you all. I'm so sorry I can't be there in person to see you and to watch your faces and just to give you a hug. I miss my St. George's community. Tom and I are up in Vernon for the last few weeks, and we've been trying to spend as much time as possible up here, but it's really nice to see all your faces, and thank you for trusting me to deal with this topic, which I think many of you know is so near and dear to my heart. Hi, Judith. Saw you just join. So what I'm going to do today is I'm going to speak. I have a PowerPoint presentation, which Alita is now going to pull up. When she does that, there we go. And she's going to click through that presentation for me. I certainly, even though I've used the Dioceses of Newark, our symbol there, I just want you to know that this is really my presentation. It has nothing to do with the Diocese of Newark. It has nothing to do with my position as Chancellor. This is all my position as a private citizen, so you know that I'm not implicating them in any of my positions here, although something tells me they would probably be very supportive of my positions. So I'm going to talk to you about 3 aspects of reparations, primarily the legal case for reparations. Alita, if you could just move the slide to the next one, I would appreciate it. I'm also going to talk about the spiritual side of reparations, and importantly, as we move into hopefully a new administration, the potential legislative side of reparations. And all 3 of these areas, I'm not going to divide them up into 3 sections, but I'm going to intertwine them in a group of stories I'm going to tell you. And these stories are my story and how I got involved in reparations, in particular a lawsuit that I brought, believe it or not, 16 years ago with 19 other attorneys. The second is my clients' stories, the stories of my clients, the descendants of enslaved African Americans. And the other perspective I'm going to give you is a perspective in the Bible as well. I think all those are important when we're speaking about a church commission and committee, and as we look at our roles as Christians in our faith commitments. Next slide, please. So the first story I want to talk about a little bit is a story that's not mine, and it's not my clients, but it's the story of the Bible and the woman at the well, and that's in the Gospel of John. And in that story, we know that Jesus is returning from Galilee to Samaria, and he's exhausted, and he comes across a woman who's trying to get water at a well at noontime. And he asks the woman for water, and she's stunned by this. Why are you, a Jew, asking me for water? Is her response to Jesus. And in the context, it's important because the Samaritans were looked down upon by the Jews and others who viewed themselves as the chosen ones. But also she has a few other strikes against her. She's a woman. And because she's at the well at noon, she has a reputation issue. And Jesus makes this clear when he mentions to her his awareness that she had multiple husbands. Addressing this directly, Jesus says, if you knew who I was, you would know God is the bearer of living water. God is coming, and true worshipers must worship God both in spirit and truth. And the gospel reading becomes our engagement in truth, but also society standards for those who are chosen versus God's standards for those who are chosen. You can move to the next one, Alita. And from these images of water comes another image of water, this time of a people, ancestors of us all, who traveled not because God chose them to travel, but rather as a people chosen by others for profit and exploitation. Chosen not of one family, but rather ripped from their families. Lita, you can move to the next one. And what are some of the basic truths of this? 8 to 50 million people arrived in chains in the New World. It is estimated that for every one that survived, one died en route. The examination of 400 remains at a burial ground in New York City, a slave burial ground in New York City, showed that 40% of those were children under the age of 15 who died of malnutrition. The adult skeletons showed that many people died of unrelenting hard labor, in that the skeleton showed that the strain was so severe that muscles were pulled from the bone. Enslaved African Americans in large part built our nation. They built the Capitol. They hoisted Lady Liberty on top of her dome. They cleared the forest between the White House and the Capitol. And they fueled the prosperity of our young nation to the extent of $1.4 trillion. And despite legal promises for emancipation and reparations, the promises remain largely unfulfilled. Briefly enacted after the Civil War was Field Order 15 by General Herman, which is now known for the famous 40 acres and a mule. And even though that was promised shortly after General Sherman's enactment of that, or his writing of that, Andrew Jackson reversed the order. Jim Crow laws, black codes continued as institutional racism for at least another 100 years. And while some people believe that full emancipation came in 1964, I think now we're all beginning to really question whether or not that happened then. As you all know, African Americans still lag behind their white counterparts in almost every social yardstick, from income to education to housing to infant mortality, to the high mortality rate of African American women in childbirth. It's phenomenally higher than that of white women. The death of African American men and women in police custody that we're now becoming so we're seeing more and more. Obviously it happened before, but with cameras, we're all being witness to it or bearing witness to it. Dalton Conloy pointed out in an article in the New York Times that economically there are disparities as well, that a typical white family enjoys a net worth that is more than 8 times that of its African American counterpart. And what does that mean generationally? It means that 80% of lifetime wealth accumulation results from gifts from previous generations. meaning African Americans are still struggling to overcome a staggering loss of income from generations of missed wealth transfers. And even though John Conyers introduced his bill, H.R. 40, to create a commission to study reparations, almost 30 years later, that is not passed through Congress. And the last time they put it up was in 2019, after the election of Democrats in the House. I think that's pretty significant. And of course, McConnell says in his statements at the time it was introduced in 2019, I don't think reparations for something that happened 150 years ago, for whom none of us currently living are responsible, is a good idea. And I can tell you that 18 years ago, when we brought our case, or 16 years ago when we brought our case, this was the same argument that was being presented by the conservative media at that time. Exact same argument. W.E.B. Du Bois, 40 years after the Civil War. I'm sorry, Alita, I left you behind a little bit there. I'll let you catch up. Oh, well, no, I think you have to go back one.
Yes.
There you are. The nation has not yet found peace from its sins. The freedman has not yet found in freedom his promised land. In some ways, this quote is as relevant today as it was 120 years ago when he made it. So what does the Bible teach us about the story of the women in the well? Who does God choose as chosen, and who does society view as those chosen? What does the Bible teach us today about who comes to the well at noon and who comes to the well at prime time? And what does Jesus teach us about our work as Christians as it relates to those people that are viewed by some as less equal? How does God's living water transform us all into one people that leaves no one of us thirsty? So that story and those questions became a part of my life 18 years ago, before I filed the slavery reparations lawsuit. And it starts with a client that I had back then. And for those of you that are sensitive or want not to hear this portion of it, it gets a little graphic. So if you want to mute yourself, please feel free to do that at this time, or mute me. Feel free to do that at this time. I will be also discussing some of my other, the stories of some of my other clients, and they get pretty graphic too. So again, what I will do is give you a wave when we're through this portion of it, to give you a sense that you can tune back in. Alita is also going to, in the chat room, tell you when it's safe to rejoin if that's going to be difficult for you to hear these stories. Okay, so 18 years ago, a legal secretary in my office came to me and she had a problem with her son. He had been arrested. And this was not an uncommon situation for me at my law firm. I was a former prosecutor in Manhattan. And so it was not uncommon for people to come to me with the stories of their kids when they got arrested for minor types of crimes. And I would typically represent them pro bono or for a small fee, because it was something that I was very comfortable doing and didn't really require a lot of time. So when she told me about the stop and the situation of her son's arrest, I was happy to help. It became a lot more complicated than I thought it was going to become initially. Kareem was a 17-year-old kid. He had just gotten his license, and like most 17-year-olds, he took to the streets to drive his car around, which was a sort of junker of a car that he called his hoopty. And he was stopped by the police in what turned out to at least start to be a fairly common story. But it was there that the story took a very harrowing turn. They thought that he might be able to identify, and they stopped him because they thought he had knowledge of a car that was stolen. and that had been running up and down Route 78 outside of Newark, and he was in the Newark area. He knew nothing about that stolen car, but they assumed he did. And when he truthfully told them that he did not know anything about it, a police officer, they put him up against a wall out by an old warehouse in Union. And a police officer, there were several police officers that were part of the stop, but one police officer pulled out a pair of pliers. They held the pliers to his genitals. And when he again said that he did not have any knowledge, they squeezed the pliers. Sorry. Yeah, I'm fine. There was something so chilling and institutional about that one act. To me, that one horrific act led to an inescapable conclusion that I couldn't run from. It seemed that the act had its genesis in a learned brutality. And it felt like the only way that brutality could have existed, or where it could have come from, was slavery. It's the only thing that made sense to me. And years after I started the lawsuit, a law professor, his name was Keith Hyleton, later put into words my instinct about that one event. And he said, American slavery, unlike Roman slavery, you can move to the next link there. Yeah, you can move to the next one. I'll start again. American slavery, unlike Roman slavery, contributed greatly to the spread and resilience of racism. Slavery gave racist attitudes an economic function that would otherwise not have existed. This need justified the use of oppressive force. Like a resilient virus, racism has a tendency to replicate itself in successful generations. Kareem testified in court for the first time. He'd never testified in court before. I showed him how to tie his tie. He came in a suit and a tie, which I always ask my clients to come to court in. And like a lot of 17-year-olds his age, he didn't know how to tie a tie. So I stood behind him, and his mom and I helped him to tie his tie. And we went into municipal court because I convinced a prosecutor who initially didn't want to bring the case that this was an assault. He finally brought the case, and so there we were, 8 other spectators, his mom and me, and 8 other people. Does anybody want to guess who those 8 other folks were in the room? Yeah, they were police officers from the police force, and they showed up in their uniforms, and they showed up there for one purpose: to intimidate him as he was testifying. It was not long after that that Kareem was treated in an emergency room. I got a call from his mom late one night with suicide ideations. And shortly thereafter, I received a letter from an officer, anonymously from the police force where this happened, which I'm not at liberty to disclose, and I'll talk about that too. It, of course, told what I already knew, which was the event happened. It happened the way Kareem described it as happening. I brought another civil case for his actions, brought it in federal court. We eventually settled the case. It was a tough case. It was a tough case to bring because obviously he's the only witness. It was a tough case to bring because the medical testimony that I was going to get was not great. It showed an injury, but it didn't show the type of injury or the depth of an injury that was going to be awardable in significant sums in a district court in New Jersey during those times. So we did settle the case, and the case had an airtight non-disclosure provision, of course. And that never sat right with me. There was something about that case that just left me, there's got to be something more we can do. There's got to be something more that I can try to do. because it's just not right. And it was not until, and you can keep moving, Alita, it was not until several years later that I had an opportunity in another case I was working on, which was a whole series of people that died in a train fire in Austria. And in that case, I was working with some Austrian attorneys and also some attorneys from the United States. And we were in a bar in Vienna. And I was talking to the attorneys, and somehow we got started in a discussion about reparations for Holocaust. And two of the attorneys that were in the bar with me, the American attorneys, had taken on this case where they had brought a suit on behalf of survivors of the Holocaust. And they brought the case in the United States, in the actually Eastern District, which is Brooklyn, to try to gain profits back for the Holocaust survivors as a result of lost profits, unpaid slave labor from Holocaust folks that were forced to work in corporations during that time, but also companies that had looted assets of the survivors. And they used a theory that was called unjust enrichment. And that theory has its precedence in Supreme Court, and a Supreme Court ruling that dates back to 1889. And basically it says that those who receive profits or money from an improper or even immoral act must disgorge those profits back to their proper beneficiaries. It's an equitable theory, which means that courts have a fair amount of discretion as to whether or not they're going to utilize it, but it's there to be utilized. And in that particular case, in the Holocaust case, what they were able to do, they sued Swiss banks, they sued some other corporate entities. They were able to get a settlement in the case. And the settlement was not insignificant. It was a pretty decent settlement. And somehow, in my mind, the whole notion of this theory that they had used in that case fairly successfully, they never went to trial on the theory, but they got through the initial phase of motion practice. And before they got into the next phase of the trial, the case settled. And so what I thought is, couldn't you use that same theory for descendants of African-American slaves? Wouldn't it work? And we were up until 2 in.the morning. And they were telling me how they did it. They were telling me how they filed press releases. They were telling me their whole strategy behind the case. And boy, it just lit, this light bulb went off in my head. And I was like, hey, I wonder if I could do that. And I had worked in a large firm after I was a prosecutor. So I had worked on some of these bigger cases where you can use those legal theories, and felt fairly comfortable that I might be able to throw together a case that was legitimate, that would stand the test of some judge trying to dismiss it, or would withstand the test of us being sanctioned for bringing it, because it's you know, it would be viewed upon by some very, very negatively. And so I thought about that more. And the end result of that was, somewhere along the line, I read an article by a woman. Her name was Deidre Farmer Paleman. And Deidre was she was a lawyer, but she wasn't a practicing lawyer. And she was in graduate school at the time, somewhere up in Boston, and she had done some research. And I was, you know, reading through the newspaper one day, and I came across this research that she had done that connected the transatlantic slave trade, companies that had profited from the transatlantic slave trade. And all of a sudden, I was like, that's a potential plaintiff. And I have potential defendants here. I have these corporations that had profited from the transatlantic slave trade. So I have potentially a case. You know, I could put that case together using that same theory that they used in the Holocaust litigation. So I called her and I said, have you ever thought about this? You know, what you're thinking? And over the next 3 or 4 months, she and I worked together. We gathered a group of attorneys. I gathered a group of attorneys. And it led to us filing a lawsuit in 2002. The first suit we filed was in New Jersey. We eventually filed 4 more around the nation. We had 19 attorneys, one who included the former head of the TRC in South Africa. His name is Demisa Nzabesa, and he signed on to our litigation. When we first filed, the press covered it. We got a dramatic response from the press all over the world. And there were interviews that we did. I appeared on CNN. I appeared on multiple TV stations at the time, radio stations, as did the other attorneys in the group. And what we did is we used those 16 corporations that our research had established a connection, our Deidre's research had established a connection between those 16 corporations and profits from the transatlantic slave trade. And the representatives were those who could establish themselves as descendants of African Americans. And while I am going to get into a little bit of the legal theories we used, the primary one I already described to you, but I want to talk to you a bit about my plaintiffs, the clients that we represented. And again, a trigger warning on this one, and I'll sort of wave when we're past it. Richard Barber, 72-year-old at the time we filed the litigation. He worked for the Clinton administration in a sub-cabinet position. And he was the grandchild of a master slave owner, and his dad was a sharecropper. As a boy, Richard delivered papers to the owners of stately homes that his grandfather had built. And he recalled the story for me and for the other attorneys of his great aunt's and Anna's emancipation from slavery. That's pretty important today. Miss Hannah Hurdle Toomey, I'm sorry, she was in her 80s. She told the story of her father who was enslaved and who he showed her the whipping scars on his back. And he told her the story of his brother being sold off on an auction block. Miss Emma Clark, she was a 95-year-old woman from Texas who, one of our Texas attorneys, we started out with 2 or 3 representative plaintiffs. And as the case got covered in the news, we were contacted constantly by other descendants. And as we were contacted by other descendants, we came from first we had great-grandchildren, then we had Mr. Barber, whose grandfather was a slave. And then we got to the point where we had people whose dad was a slave, like Mrs. Hurdle Toomey. And then eventually, and shockingly to most of the attorneys on the case, we got to people who were enslaved, who had been enslaved. And this was Ms. Emma Clark. She was a 95-year-old woman from Texas. And she told her story to our attorneys while she was incapacitated in a nursing home. And she told us that she was willing to undergo questioning by defense attorneys to retell her story. And her story involved being enslaved on a dairy farm in Texas in 1930. Yes, I said 1930. When one of the attorneys in the interview asked her why she didn't leave, her quote back to the attorney was, "I could not, I was chained to the bed at night." Ms. Clark died on the 4th of July in 2003. A week before her deposition was to take place, but her story was told by her sons and later aired on NPR. Mr. Kane Wall, he was a 101-year-old man. Again, we had filed the case. We were well into motion practice, and we got a call from Mr. Wall. One of the attorneys got a call from Mr. Wall telling us the story about how he'd been enslaved in the backwoods of Louisiana up into the 60s. Again, we had 19 attorneys on the case, and we heard this story, and we had been so meticulous about how we were presenting the case to make sure we had the facts right, to make sure everything that we were doing was truthful, because we knew it was going to undergo tremendous scrutiny, and it did. So when we got to Mr. Kane Wall and he told us his story, all the attorneys agreed, we've got to go down there and we've got to interview him because we have to be convinced that he is, that this is a legitimate story. And we all went down to Louisiana. Not all of us, 6 or 7 of us went down. And Mr. Wall told us his story. And around the room of these professional attorneys who are all pretty rough and tumble folks that are used to litigation, used to seeing really bad things in litigation, used to handling really bad things in litigation. Every attorney in the room was crying by the time Mr. Wall finished his story. And when we started out, we didn't use his name, we used John Doe when we first filed the complaint, because it soon became known in Louisiana that he was talking, and he and his family were threatened. And that's also my first experience, by the way, with the Black Panthers. And while I had grown up sort of having this white person's understanding about what the Black Panthers were, what I came to see is the group that showed up down in Louisiana provided food, provided security, provided moral and spiritual support to Mr. Wall and his family during our interviews. Mr. Kane's story was aired on Nightline, and Ted Koppel told the story. And his daughter was also interviewed on by Ted Koppel on Nightline. And the daughter described how her and her dad and her siblings were kept in a shed behind the main house in Louisiana in the 60s, and how she was fed from a bucket of scraps that were left outside the landowner's house every night, and that they were fed after the dogs got fed.
In about half an hour.
So these are the stories I heard. There are stories I can't tell you because it's too painful for me to talk about them. But I will tell you they shape me, and they shape my resolve. They shape my continuation, my resolve to continue with the cases that we were pursuing, as did the 19 attorneys I worked with. That's the end of the trigger warning for those people that want to join back. As I indicated to you, the primary theory of the case was one of unjust enrichment that had its roots in a Supreme Court case. And I explained to you what that was. But there's a whole series of other precedents. And Alita, you can click it through to the next one. What are these legal precedents that we studied before we brought the case? Japanese Americans, pursuant to the Civil Rights Act, were provided $20,000 to each descendant who was interned during World War II or who lost assets. The interesting aspect about that case is that it started as a lawsuit. And much like our case, the attorneys filed it in federal court. It moved up to a circuit court, and it eventually made its way to the Supreme Court. The decision was called Hohri, H-O-H-R-I. And in that particular decision, the Supreme Court eventually upheld the dismissal of the lawsuit. But what happened after that dismissal was that there was legislation passed, and that legislation provided $20,000 to each descendant. And so the significance behind that is, even though the legal case failed in the courthouse, that it did result in an ultimate legislation that resulted in reparations. Other examples, 1992, more than 2,000 human rights abuses were documented by a Chilean commission, and that resulted in legislation that allowed for a range of different resources, economic benefits for the victim and their families. Canada has provided a reparations package for the First Nation children. These were children that were taken away from their parents to attend boarding schools and were denied access to their culture. New Zealand established a process to address the wrongs committed by the British against the Maori people in the 1800s. In Puerto Rico, Governor Rosillo publicly apologized and offered restitution of up to $6,000 each to thousands of independentistas and others who were spied upon by the police intelligence units. I think I missed, did I miss the Chilean?
No, didn't.
I did miss the Chilean, right?
Yes.
Oh, no, I didn't. In 1992, after 2,000 human rights abuses were documented by a Chilean commission, they granted, I think, I'm sorry, I said that one already, I apologize. 1994, Governor Lawton, Chile signed into law a bill that resulted in the payment of $2.1 million to folks who were the descendants of the 1923 Rosewood Massacre. And that was where white lynch mobs killed 6 black folks and drove others from their homes. Under this bill, it provided $150,000 to each of 9 survivors and monetary awards to 143 descendants. The apartheid case, another case that I'm involved in, still involved in, there was a minor victory in that case, and that some of our clients were able to collect, 16 of our clients were able to collect a small amount of money arising from them being victims of apartheid in South Africa from corporations. GM ultimately provided a minuscule amount to settle some of their claims, and we're still in the process of trying to distribute that. And that was, I think we're talking 14, 15 years later. What is the basis in international law? International law is interesting because slavery is a crime in almost every international declaration and treaty. The problem here with international law, however, is that the United States has not signed on to any of these international treaties. So the problem in trying to include those treaties in any kind of civil litigation becomes problematic because the US has chosen not to be a member to any of those treaties. What are the stumbling blocks that typically were presented to us and are presented to us still as a result of the litigation that I was engaged in? Well, the first one is the statute of limitations, right? And those of you who might not know the law probably do know that a statute of limitations limits the time from which the harm occurs. You only have a certain period of time, usually a few years. The longest ones tend to be only 10 years. Typically, they run out after 6. And after that, your claim is barred. So how do you deal with something that happened 250, 260 years ago? Well, you know, again, the law has little escape hatches in it. And one of those escape hatches from a statute of limitations is what's called the discovery rule. And that basically provides that until you discover the source of the harm, or until you discover like maybe the corporation that has a connection to your ancestors' slavery, you can't bring a case because you don't have any knowledge of it. And so it's called, the principle is called equitable tolling. And in the Holocaust case, they had to get over that, and they did. So they told the statute of limitations for 40 years, and that made sense. So there was precedent for tolling the statute. The second thing is you can change the statute. Right now in New York and New Jersey, they have both entered into statutes that allow victims of sexual abuse that occurred when people were young. They've opened a 1.5 year window for people to bring lawsuits. So it's always possible to change the statute and extend the statute of limitations for a particular purpose. The second sort of challenge with any of these legal cases, excuse me, is establishing a direct connection between the corporation, which is the defendant in the case, and the enslaved individual. So one of the defendants in our lawsuit was Aetna because they insured slaves. But for instance, we couldn't show that Mr. Barber or any of the other representative plaintiffs in our case, we couldn't show that he was insured by Aetna. So is that a possible failure that will mean that no one can ever bring a reparations case ever on behalf of someone in this circumstance? And I say no. And the reason I say no is the DES cases. And what were the DES cases? DES cases were cases brought by women, moms who had ingested a particular drug called diethylstilbestrol. And the result of that drug was it left women with various physical disorders that were directly a result from the ingestion of the drug. There were lawsuits that were brought, I'm going to say in the 90s, because I worked on them. And in those particular cases, the moms were not able to tell you what drug they used. So that's the same issue here. You weren't able to directly connect the defendant to the plaintiff. So what did they do in that case? The courts came up with a theory called market share. They sued all the entities that produced DES, diethylstilbestrol, during that time, and they divided up their percentage market share. And then what happened was they all had to, whatever the damage was for a particular woman, they all had to just pay that percentage share. So certainly the courts found a way around this particular issue in another case that provided a precedent for it. Okay, so what's one of the other potential legal problems in the case? Not only can you have a problem with a horizontal sort of causal chain, you can have a problem with regards to a vertical chain. And what do I mean by that? Again, how could we establish a connection that Mr. Barber's grandfather, who was insured by Aetna, assuming we could make that connection, can we prove that the grandson is entitled to a benefit from the labor of the grandfather? And again, there's an example of that in the DES cases. There's also an example of that in the Holocaust case. But in the DES cases, the granddaughters who suffered harm were able to collect from the pharmaceutical companies that produced the drug because they could show that there was an intergenerational harm from the original ingestion of the drug. My argument and the argument we made is the same thing, that it's fairly easy to show a connection between the harm suffered by descendants of African-American slaves. And obviously the disparities that we've looked at prove that point. So what happened with our case? We had two decisions over, I don't know, a 3 or 4 year period. The first decision, the judge dismissed the case in a decision that was over 100 pages. That decision was very derisive of the legal theories in the case. The judge that we heard it before was a judge that sat in Illinois. He had a reputation, which I looked up as soon as the case was assigned to him, and he had never, ever found in favor in a civil rights case on summary judgment. And he had over 100 cases. So if you think maybe there was a little judge shopping that happened between the time we filed the case and where it ended up, I came to believe that there was. I don't think it was unintentional that we landed before a judge that had never found in favor of a civil rights case. But be that as it may, we repled the case. And when we repled the case, the judge came out with another 100-page decision. All of these decisions are reported, by the way. And his second decision was vastly different from his first decision. And what had happened in the year between was there was a lot of publicity, a lot of press, a lot of law review articles that came out, and gradually people were getting acclimated to an idea that there was a legal basis for reparations. And all of a sudden the judge had to take it more seriously. So his second opinion was much more serious and weighty than his first one. He still messed it up. He still got theories wrong. But nonetheless, it was a more serious look. And of course, we were able to eke out a small victory. We appealed his decision. It went to the 7th Circuit. And the 7th Circuit reversed the judge on one small point. And that small point was when we filed the litigation, all the defendants said, hey, we don't have a connection to the transatlantic slave trade. That's wrong. And the reason they did it is they were nervous that they were going to lose the business of African Americans or people that supported the position. So they were afraid of boycotts. So they said that they had never, there wasn't a connection with their predecessor companies. Well, obviously, we're not going to bring a lawsuit if we don't have a factual basis for the claims we're bringing. So we turned around and added a consumer protection claim to our lawsuit. And the consumer protection claim, which is basically these guys lied, and consumers have a right to know. That was the claim that got reversed and sent back for us to be able to continue our lawsuit, not on the underlying reparations case, but on the consumer protection claim. And at that point, we all felt that having that judge decide the decision was only going to create bad law. So we dismissed the case. It's called a stipulation without prejudice, so that it would allow us to bring the lawsuit sometime in the future on a same theory as the one we had previously done. So, yep. What were the victories? Were there legal victories? I tend to think so. I mean, there are days when I was in the middle of it where I didn't feel that way. But it did receive worldwide attention. There were scholarships that were presented by some of the corporations we sued. There were tons of law review articles written about the case that were very favorable to the legal theories that we had presented. I had an opportunity to write a chapter in a book that was distributed worldwide about the case in the framework of legal claims for reparations. And Alita, if you could move to the next one. Yes, so there's other litigation. It spurred the apartheid litigation, and we were able to accomplish some victories there. The clients that I had, they never viewed the case as something they lost. They always viewed the case as where they got their day in court, and that was really what they were looking for. They were looking to tell their story. Those stories are preserved for future historians. The church then started efforts around confronting reparations. We can talk a little bit about that in our discussion. And I think it was the first time that the theory was accepted by the mainstream media, that the claim for reparations is not one that's a charity claim. It doesn't derive from people deciding to bestow something on descendants. It is a legal entitlement. And it gave a legal framework to a process that many folks viewed as illegitimate. Or at least I hope it did. And as my client, Mr. Barber, used to always put it in his interviews, is a debt until it's forgiven, and I am not in a forgiving mood. So, next. Is there potential opportunity for more lawsuits? I see it every day. So one of the cases that I saw, which sort of triggered my interest, was a case in Georgetown University, where they admitted they had slaves that they utilized at the university. And many, of course, hundreds of years ago, right? And they sold off those slaves, and that would have provided that link that I was looking for with regards to the causal chain, the horizontal causal chain. And Georgetown jumped out in front of it. They were able to contact the descendants, and they were able to arrange some form of reparations to those descendants. I think they did it to head off a potential lawsuit. I'm pretty clear they did it to do that. But another lawsuit that sort of was percolating in my mind was a case with Jack Daniels. I don't know if you guys read in the press. This was, I'm thinking 3 years ago maybe, that the person that came up with the formula that Jack Daniels uses for his whiskey was an enslaved African. And they referenced that in one of their stories, and they sort of wanted to provide some level of acknowledgement for that. And they were in touch with the descendants as well. But there was never a claim for, there was never an assertion of reparations. There was never an attempt to make reparations back to the family members. I think one of the things that we encountered was we had old judges, and the bench is pretty pretty rife with older people. And I do hope that as the next generation comes along and you have judges that are more attuned to these issues, that we will begin to see maybe more victories in these cases. What about legislative opportunities? Aside from the ability to pass HR 40 for 30 years, every major Democratic candidate had a position on reparations this time around. That's pretty hopeful. I don't think we've ever seen that before. But let's look at what those policies were. If you examine them, you will see almost every candidate was just willing to go along with what was in HR 40 all along, which was just, let's have a commission to study the idea. Nothing more than that, no meat behind the packages. Bloomberg didn't have any policy at all. But aside from others, who went a little bit further than just the HR 40 suggestion? Alita, if you could move to the next one. The next one.
Oh, sorry.
No problem.
There we go.
There you go. Marianne Williamson, who some people viewed as a little bit out there, which is scary because she suggested payments. Steyer describes it as a debt due. He talks about describing the Slavery Reconciliation Commission. Castro, I liked his position, talks about it as a debt due. And his quote is, if you compensate people for taking their property, why wouldn't you compensate the person who was the property? Buttigieg named specific policy changes that he suggests will be a part of, or suggested would be a part of his plans before we got to a reparations committee. So that was a little bit more than the others had suggested. You can move to the next. Where do we go from here as Episcopalians? Dr. Pamela Cooper White, who's an Episcopalian theologian, tells us, and she wrote this with regards to proposals around the new Title IV when they were introduced a while ago, but I think it's applicable here, is our goal as Christians is the restoration of right relation in the community through truth-telling, through the healing of the wounds in this part of the body of Christ, and through reconciliation. You can move to the next one. And she describes reconciliation as something that's not easy. It just doesn't happen by a blanket apology. It's a difficult process, and it's not meant to be in the sense of premature, cheap forgiveness, but it has to be part of a whole community effort. And she says, we are called by baptism to be reconcilers, restorers of the concilium, the whole community. God called and blessed as children of God and are precious in God's sight. And so what I came to learn from my privileged vantage point of hearing the stories of Deidre Farmer Pellman and the stories of Richard Barber and Miss Hannah Toomey, Miss Emma Clark, and the Wall family, is that they were indeed chosen by God. And they certainly carried God's message to me. And that message was one we heard in our service today. They had survived. They had endured. Their endurance built character, and that character produced hope. And that hope was palatable in everything that they did, in every way that they acted, in the strength that they showed to come forward, and in the strength Kareem showed to come forward and testify in that municipal court in front of 8 police officers. And their faith was every bit as deep as Jacob's well. And what I learned from that experience is they fed me cup after cup after cup of living water. And that's where I will end our presentation and hopefully open it up to some questions that you all might have.
Oh gosh, I'm so.
All right, you folks are unmuted.
I'm able to hang with my work.
And let's see.
Just music.
All right. Okay, so questions, anyone?
Yes.
Go ahead, Judith.
Okay. So first of all, I want to say, Diane, how deeply moved and impressed I am with the kind of work, the focus, the deep spirituality that was evidenced in the work that you have done and are continuing to do. And I cannot even come up with the words to applaud you and your team for doing this over so many years through all these legal twists and turns. I have a niece who's an attorney who just helped me with a particular case, which I won't go into, but I am just in utter amazement that you continue this enormous struggle for justice from the origins of slavery 400 years ago, race-based slavery. I would just add one comment for the professor who mentioned Roman slavery. And as someone who taught about that topic at Seton Hall for many years, I used to say to my students that slavery in the ancient Mediterranean world was never race-based slavery. There was no concept of race during that time. There was only a notion of the peoples, what were called the gentes, which are different kinds of groups of people. So what I would say to my students was that anyone could have been a slave. It just meant you were in the wrong place at the wrong time, and the pirates came to your village, because there were pirates then, and hauled you off and took you to the market, and you got sold into slavery. But if you were able to reach your family, and if your family had enough money, they could buy your freedom. Now, the most important point about ancient Mediterranean slavery is that it never meant anything about the inner reality of the person who was enslaved. It never meant anything about the nature of those folks who were higher, lower. There was no sense of hierarchy in that sense of slavery. I used to call it with my students equal opportunity slavery. And that at any point, anybody could be unlucky enough to get sold into slavery. It said nothing about the nature or the character of the particular person who was sold into slavery. Okay, so that is a huge difference between slavery in the ancient Mediterranean world and race-based slavery that started in the 14th and 15th centuries. Okay, I'm done.
Thank you, Judith. Thank you. I think Hyalton's comment really got to, I think, one of the things that makes it so different from Roman slavery, which was the economic piece of it,
Yes.
but also the economic piece being tied to race.
Yes, absolutely, yes. Because sometimes my students would hear slavery in the ancient world and make all kinds of assumptions about it, that it was similar to what happened 400 years ago. So it was like the teaching moment for me to highlight these really important differences, that slavery was not the same.
Yeah.
Which gave them another model to think about how horrific race-based slavery was.
Agreed. Thank you.
Sure.
Diane, I'm sure you're aware of the Episcopal institutions that have started pledging money for reparations for slavery. A couple of dioceses, I think it's Virginia Theological Seminary, and the form that these pledges make are not giving individual awards to individual people, which has all kinds of problematic freight with it, but pledging money to support and help the African American community, build something to try to overcome some of the disadvantages of slavery. of being descended from slaves.
Thanks, Kirk. When we brought our case, we sat around in a room and we had about as many, maybe a few more African-American attorneys than we had white attorneys at the time. And we debated what we were going to ask for in terms of relief. And we were asking for a commission that would then decide how the reparations were going to be paid out. And I still believe that that's a choice that's not really ours as white people, I'm going to say, to make. I think that's really a decision that should come from the group of people that were most affected by slavery. And so my sense on that is if HR 40 does come about, I think you do need to take into consideration the voices of people that do think that an individual check is warranted. And I don't think it should be the community as a whole that makes that decision. That's just kind of my read on that. When we were in the reparations case for apartheid, one of the things that happened is GM offered us some money to settle some small portion of the case when GM went into bankruptcy. And the class action aspect of the case got rejected, but they did grant a claim to the 16 people who were our representative plaintiffs in that case. And essentially, we were then charged with trying to figure out how we were going to divide up the sum that they were offering to the 16 people. And we turned that decision back to our individual plaintiffs, which we are required to do by law, by the way. We have to have the consent of them before we can settle. Their decision, very plainly, was they wanted the money divided. And that's kind of what we did. And so that's kind of why I have a feeling that that's not really my choice to make. That's the choice of other people. So, other questions? I see.
I have a point. Am I on the, can you guys hear what I'm saying?
Yes.
I want to pick up on what Kirk said. I think it's really key to consider the long-term effects of slavery. I think giving somebody a payout, it's good, but it doesn't solve the problem. Because, I mean, we're talking about a multi-generational degradation that we see all the time in, kids dropping out of school and that sort of thing. So I think there have to be some major systemic changes, like the demands that are being made now for better education and so forth and so on. And that's going to make a difference. I mean, I think that's much more important than individual lawsuits. I'm not against individual lawsuits. I mean, it's important. It's a way of calling out the responsible people, like Aetna. I don't know if they ever had to pay anything, but it ought to be known that Aetna had a history of supporting the slave system. It ought to be known that Brown Brothers Harriman comes from the Brown Brothers Company, which was a major slave trading company in Rhode Island, and that Brown University is named after them. I mean, these kind of things need to be known. And I also, this is a slightly different point, but just to go back to that horrifying story about Kareem, that was the kid who
Yes.
was stopped for driving his own car.
Yes.
I have a problem with non-disclosure agreements because in a way it really shuts down the discussion. I mean, it might have been better for Kareem if he had been free to shout from the rooftops what happened to him, and he can't talk about it. The family can't talk. So that's a kind of castration in a way that's really not good. Not that any form of castration is good, but it's a problem, I think.
So David, a couple of things. One thing is you start out and you said that, you weren't for individual checks because it's a handout.
Well, I'm not against it. I just,
Well, no, the only thing I wanted to say to you is the notion of it being a handout is one of the things that we as attorneys are trying to shift the view on. Because the view is it's not about a handout, it's about a debt. And it's about a payment to folks for the debt of, you know, all this unpaid labor. And so how you decide you're going to do that is not a handout in that sense. It's
you're right. I'm
payment.
sorry. I should never have said
No,
that.
no, that's okay, because I think we all kind of lapse into that sort of thing. And in terms of, I don't think it's mutually exclusive to, and I'm not necessarily saying I'm in favor of individual checks. There's days I am. I don't think it's my choice to make, but there's no reason you couldn't do that and do other systemic changes that you've suggested. The two are not mutually exclusive. You could do both. Or at least that would be my argument. And the other thing about why lawsuits are important is it because it changes the dynamic of looking at it in terms of it being a debt versus in terms of it being, you know, something that like is a handout. And so that's why I think it's important that the lawsuits proceed along with legislative actions.
That's a good point. I stand corrected.
Well, I did my job then, right? I successfully
right.
argued another point.
Right, yeah.
Diane, have any efforts been made for restitution for the descendants of the Tulsa massacre?
Right.
Oh, that's a really good story, Ron. I'm glad you asked it. So at the time we were sort of moving forward with my case, and Deidre basically chose my firm over some other firms. And one of the other groups that were bugging her to bring a case was Michael Hausfeld and Johnny Cochran. And at that point, they were sort of moving through their own work and research about reparations, and they were talking about bringing a big class action lawsuit, similar in theory to my structure. And the reason for that is Michael Hausfeld, who's an attorney down in DC, was involved in the Holocaust case. So he was operating in the same legal theories, and we sort of tried to see whether or not we could merge their group with our group, and they were just not ready. They were not ready to do it. They wanted control over the case. It was a mess. There were a lot of dynamics there that had to do with race. There were dynamics that had to do with gender. There were a lot of dynamics. And they couldn't assure Deidre that they were going to bring the case forward, where we were saying, we're doing it. You know, you just name when we're moving forward. So what they did instead was they bought the Tulsa lawsuit. Much more limited lawsuit, not a really bad idea. In retrospect, I would sort of, I would narrow my lawsuit down the next time, or our lawsuit down the next time, to just deal with one specific issue. And that's what they did. And their case followed a dual track with ours as we were moving forward. And they lost the case. And when they lost the case, the corporate defendant in that case, and I can't remember who they brought in as a defendant. I wish I could remember. But they turned around and sued for sanctions against the attorneys. And that was always something that, you know, the 19 attorneys that I was a part of, we were all nervous, because we knew we were on solid legal ground. And trust me, my firm, I didn't want to put any of the partners in the possibility of going bankrupt because we're going to be sanctioned for bringing the case. But they came after those guys with a sanction lawsuit. And fortunately, the judge declined the sanctions, and their lawsuit was great. They did a nice job. The law was good. I followed it. You know, they were proceeding every bit in lockstep with what we were doing. But yeah, it wasn't successful. So thank you for reminding me about that.
Okay, thank you all. Diane, I think we'll close it here. It's 1 o'clock, after 1 o'clock. But thank you so much again for presenting this great topic that we shall continue to discuss more and more. Okay, Absalom Jones Committee, we will meet again on June 28th, 1 o'clock, same time. Okay.
Thanks, guys.
12 o'clock. Thank you, Diane. Thank you.
Thanks, Diane. Super.
Everybody.
Really good. Thank you.
Diane, thank you.
Thank
Really
you.
appreciate it.